Welcome to Bulletproofing Your Legacy. In today's episode, we are diving into the final installment of our recent series on wills to discuss how to protect your wishes from the challenge of a will contest. For many families we observe, the idea of their final wishes being discussed in a courtroom creates a sense of anxiety. It feels like a contradiction. You work a lifetime to build assets to care for your family, yet the document intended to distribute those assets could become a source of conflict. But here's the SafeSimpleSound perspective. This is not a moment for fear. It is a moment for opportunity. By applying systematic thinking, you can take steps today that provide clarity and security for tomorrow. Whether you are just starting to draft your first will or you have a complex estate with a blended family, this episode will give you 4 specific, actionable strategies to ensure your voice is heard clearly, even when you are no longer there to speak it. We will guide you through the why behind will contests and the how of preventing them, all through our S3 approach. Let's begin by establishing our foundation. In our practice at SafeSimpleSound, we often say that clarity is the antidote to conflict. To understand how to bulletproof a will, a term we use to mean making it resilient and clear, we first need to understand the environment in which challenges arise. From a safe perspective, we want to remove the emotional volatility that leads to legal battles. From a simple perspective, we want to ensure the language and execution of your documents are easy to understand and hard to misinterpret. And from a sound perspective, we want the legal and financial evidence to be undeniable. In our recent blog post, How to Bulletproof Your Will, we identified that while every family situation is unique, most will contests boil down to 3 specific legal arguments. Understanding these is not about learning complex law. It's about understanding human behavior and procedural necessity. The first and arguably most common challenge is based on lack of legal capacity. This creates an either-or dilemma in the legal system. Either the person was of sound mind or they were not. A challenger might argue that the person creating the will, the testator, didn't understand the nature of their assets or who their heirs were. The second challenge is undue influence. This is often the most emotionally charged. It suggests that the testator was manipulated or coerced. We often see this concern raised in our observations of families where one heir unexpectedly receives a significantly larger share than others, or where a new caregiver enters the picture late in life. The third challenge is improper execution. This is a technical hurdle. Every state has strict style rules about how a will must be signed. If the witnesses weren't in the room at the same time, or if a signature is in the wrong place, the entire document can be invalidated. Now, traditional planning might look at these risks and suggest you just hope for the best, or rely solely on a lawyer to draft a document and file it away. But the SafeSimpleSound approach is different. We believe in a both-and solution. We want you to have a legally robust document and a relational framework that supports it. Why is this important? Because a will isn't just a legal contract. It is a final act of communication. When we approach this through our S3 framework, we aren't just trying to win a potential lawsuit. We are trying to prevent the lawsuit from ever happening by establishing undeniable clarity. When we look at strategy number 1 from our framework, it directly addresses the issue of legal capacity. The standard advice is often to get a doctor's note on the day you sign your will. And while our team certainly agrees that is a wise step, from a sound planning perspective, it is merely a snapshot in time. Drawing from our CFC background at SafeSimpleSound, we propose a more robust solution, the creation of a longitudinal record of capacity. Think about it this way. If someone questions your decision-making ability on the day you signed your will, a single doctor's note is good evidence. But what if you had 5, 10, or 15 years of detailed, organized financial meeting notes? When we work with families to build a financial plan, we are inadvertently creating a powerful record of lucidity. We document goals, we review complex cash flow statements, we make adjustments based on market conditions. These are not the actions of someone who lacks capacity. These are the actions of an engaged, thoughtful steward of wealth. This aligns with the principle of systematic documentation. Your financial planning process serves a dual purpose. It manages your wealth today, and it defends your legacy tomorrow. It creates a pattern of behavior that is very difficult to refute in court. This is the sound element of S3 in action, using professional process to create legal stability. Moving to strategy number 2, the technical tool known as the in terrorem clause, or more simply, the no contest clause. This is a specific provision in the will that essentially says if any beneficiary challenges the validity of this will and loses, they forfeit their inheritance. Now, let's apply the simple filter to this. It works like a safety latch. It forces a beneficiary to do a cost-benefit analysis. If a beneficiary is set to receive $50,000, but they are angry they didn't get $100,000, this clause forces them to pause. Do they risk the guaranteed $50,000 for the chance of more? However, we must also apply the safe filter here. We must be honest about limitations. Through our SafeSimpleSound practice, we emphasize that this clause is not a magic wand. State laws vary significantly. Some states will not enforce this clause if the challenger has probable cause to object. So, while we recommend discussing this with your attorney, we view it as one layer of armor, not the entire shield. It creates a financial disincentive for frivolous frustration, but it must be paired with the relational strategies we will discuss next. To fully understand how these principles come together, combining the legal, the financial, and the relational, we need to see them in motion. Abstract legal terms like undue influence or capacity can feel distant until we see how they play out in a family dynamic. Let me share a hypothetical scenario that illustrates this principle. While this story is created for educational purposes, it demonstrates patterns we see when families apply S3 thinking to retirement and estate planning. Consider a fictional family we'll call the Harrisons. The father, Thomas Harrison, is a widower in his late 70s. He has built a successful small business and has accumulated a significant estate. Thomas has 2 adult children, a daughter, Jennifer, and a son, Mark. In our hypothetical scenario, Jennifer has been very successful in her own career. She is a corporate executive, financially independent, and lives 3 states away. Mark, on the other hand, has had a different path. He has struggled with health issues that have limited his career, and he stayed in the hometown to help care for Thomas in his later years. Thomas loves both children equally. However, looking at his estate through a SafeSimpleSound lens of equity versus equality, Thomas decides he wants to leave 70% of his assets to Mark and 30% to Jennifer. His reasoning is sound. Jennifer doesn't need the money for her security, but for Mark, it is a lifeline. Here's the traditional either-or trap. In a traditional scenario, Thomas might simply go to a lawyer, draft the will with the 70-30 split, sign it, and put it in a drawer. He avoids talking about it because he wants to keep the peace. He wants to feel safe in the short term. Fast forward to when Thomas passes away. Jennifer opens the will and is blindsided. She sees the unequal distribution. Because she lives far away, she hasn't seen her father's daily life. Her immediate emotional reaction is hurt. She wonders, did Mark pressure Dad into this? Dad was getting forgetful. Did he really understand what he was signing? Because there is silence, her mind fills the gap with suspicion. She consults a lawyer who suggests challenging the will based on undue influence and lack of capacity. The family enters a cycle of litigation that drains the estate and destroys the sibling relationship. Now let's rewind and apply the SafeSimpleSound framework to this hypothetical situation. Thomas works with a team that utilizes the S3 approach. We advise him that while his decision is financially sound, the execution needs to be relationally safe and conceptually simple. First, Thomas ensures his capacity is documented. He continues his quarterly reviews with his financial planning team, creating that paper trail of clear decision-making we discussed earlier. Second, he includes a no contest clause. This creates a structural barrier to frivolous action, but the most critical shift happens in strategy 3 and 4. Communication and intent. Thomas holds a family meeting. This is a hypothetical meeting, but visualize the power of it. He sits down with Jennifer and Mark. He doesn't ask for permission, but he offers explanation. He says, "I want you both to know that I love you equally. However, because your financial situations are different, I have decided to structure my legacy to provide safety where it is needed most." He explains the 70-30 split. He looks Jennifer in the eye and explains his reasoning while he is alive and articulate. It might be an awkward conversation. It might not feel safe in the moment, but it creates long-term safety. Furthermore, Thomas writes a letter of intent. This is strategy 4. In this personal letter, attached to his will, he writes in his own voice, not legal jargon. He expresses his pride in Jennifer's success and his desire to ensure Mark's stability. He explicitly states, "This distribution is my free choice, made with full love for both of you." While this story is fictional, it demonstrates how our framework shifts the outcome. In the S3 version, if Jennifer feels a twinge of hurt when Thomas passes, she cannot claim surprise. She cannot claim Mark whispered in his ear in secret because Thomas said it to her face. She cannot claim he didn't understand because the financial records and the personal letter prove his clarity. This example shows patterns we observe when families move from secrecy to transparency. The simple act of communication removes the complexity of suspicion. The sound legal structure of the will is bolstered by the emotional context provided by the meeting and the letter. Whether you are facing this exact situation of unequal distribution, or perhaps a blended family dynamic, or a charitable gift that might surprise your heirs, the principle remains. Surprise is the enemy of a peaceful estate. Drawing from that hypothetical scenario, let's dig deeper into those last two strategies: clear communication and the letter of intent. In our practice at SafeSimpleSound, we often say that legal strategies are essential, but they often overlook the emotional reality of estate distribution. The single greatest catalyst for a will contest is surprise. This brings us to strategy 3, the family meeting. We understand that for many, the idea of discussing death and money with family feels incredibly unsafe. It feels vulnerable. It contradicts the desire to keep financial matters private. However, consider the sound logic here. If you do not explain your why while you are here, your family will invent a why when you are gone, and rarely is the invented reason as kind or accurate as the truth. This aligns with the principle of governing by consent and clarity. You are the governor of your estate. By explaining your legislation, your will, you gain the emotional buy-in of your constituents, your heirs. You do not need to reveal every dollar figure. You do not need to seek their approval. As we mentioned in the blog, it is, after all, your legacy. But providing context creates a safe container for the news. If you have a child with special needs receiving a larger portion, or if you have provided significant financial help to one child during your life, like paying for graduate school, and are balancing that out in the will, saying this out loud removes the sting of inequality. Now, let's look at strategy 4, the letter of intent. Sometimes called an ethical will, this is perhaps the most underutilized tool in the SafeSimpleSound toolbox. A will is a cold, legal document. It speaks in herebys and forthwiths. It does not sound like you. A letter of intent is not legally binding the same way, but it creates a psychological barrier to a contest. Imagine a judge or a disgruntled heir reading a personal letter where you share your values, express your love, and clearly explain, "I have made these decisions because." It is very difficult for a lawyer to argue lack of capacity or undue influence against a warm, coherent, personal narrative written in your own hand. From a simple perspective, this is low-hanging fruit. It costs nothing but time. You don't need a notary, you just need a pen and paper or a computer. Our team suggests structuring this letter to cover 3 things. 1, values, what mattered to you in life. 2, love, affirmation of your care for your family. 3, reasoning, a gentle explanation of any complex decisions. This transforms your estate plan from a transaction into a true legacy. It bridges the gap between the cold hard facts of finance and the warm emotional needs of family. As we bring this episode to a close, let's recap the ground we've covered today. We started with the goal of bulletproofing your will, not just to win a legal battle, but to prevent one. We looked at this through the SafeSimpleSound lens, aiming for a plan that is legally robust, easily understood, and emotionally reassuring. We explored 4 key strategies to protect your family from the 3 main causes of will contests. 1, proving legal capacity, using the longitudinal record of your financial planning relationship, like the work we do as CFCs, to prove your consistent sound mind over time. 2, the no contest clause, using a technical legal tool to create a sound financial disincentive for frivolous challenges. 3. Family communication, removing the element of surprise to keep relationships safe. 4. The letter of intent, adding a personal, simple narrative voice that clarifies your wishes beyond a shadow of a doubt. These steps transform a static document into a dynamic defense of your wishes. They ensure that your final act of stewardship is one of protection, not confusion. If you are listening to this and realizing your current plan might be vulnerable to the element of surprise, here is a practical next step. You don't necessarily need to call your lawyer today. Start with the letter of intent. Sit down this weekend. Write a draft. See how it feels to articulate your why. This episode draws from our recent blog post, How to Bulletproof Your Will, which you can find at SafeSimpleSound.com for the complete written framework. Through our S3 approach development, we've created a systematic way to integrate these financial and relational elements. If today's S3 insights resonate with your family's situation, we invite you to explore what financial planning could look like through our SafeSimpleSound practice. We can help families build the financial records that serve as the foundation for this kind of clarity. But either way, you are now equipped with a capability that will serve you whether you engage with our practice or not. You now understand that a safe will is a communicated will. You understand that a sound estate plan involves more than just a signature. It involves a system. Thank you for listening to the Safe Simple Sound podcast. We look forward to helping you navigate the contradictions of finance with clarity, confidence, and wisdom.